I'd like to support the mitigating amendments which have been moved by a number of noble lords, but I'd particularly like to support the amendment that's been moved by Baroness Monckton that this clause 191 should not stand part of the bill. I do so for a number of reasons. Some are to do with principle, some are to do with parliamentary procedure, but I would say that I think just listening now to the noble Lord Weir and before that to the noble Lord Hogan Howe, there are plenty of reasons why this deserves the kind of detailed examination that we have been giving it on the floor of your Lordship's House today, whatever our personal views may be. Abortion isn't just a medical procedure. It's not just about choice. It ends the life of a nascent human being. It's what Viscount Hailsham said very early in our debate is about the sanctity of human life. That is one of the key questions that we must always wrestle with when we come to this issue. Since 1967, when Parliament permitted what was supposed to be terminations carried out in rare and exceptional cases, there have now been more than 11 million abortions in the United Kingdom. That's one life taken across the UK every 2 minutes. And since 1990, we've permitted eugenic abortions on the ground of disability right up to birth, and that includes things like cleft palate or clubfoot. 90% of all babies with Down syndrome are now aborted in the United Kingdom, according to NHS figures. My lords, laws have profound consequences. We're not a debating society. We do send signals. Laws, to some extent, are like semaphore. They send a signal into society. They have profound consequences, social, personal, economic, demographic, and not just for the unborn child, clearly from what noble lords have said this afternoon, of course for the women and everybody else who is involved. But the amendments in the names of Baroness Maclean, Baroness Mayer, Baroness Lawler, Baroness Coffey, Baroness Stroud, Baroness Foster and Baroness Eaton, and my noble friend Baroness O'Lone, make clear that this does have profound consequences for women and that we should take that into account as well. Some noble lords have touched on the question of law and whether international norms require us to do this. I would just remind the committee that there's no such recognised right as the right to abortion in the European Convention on Human Rights. Decisions from the European Court of Human Rights have confirmed that the Convention doesn't guarantee a right to have an abortion, nor does it guarantee a right to perform abortions. The court has also been clear that Article 8, which guarantees the right to private and family life, does not confer a right to abortion. The court has ruled that domestic laws that prohibit abortion do not violate Article 8. In contrast, my lords, human rights laws grant protection to the unborn. The preamble to the United Nations Convention on the Rights of the Child, to which the United Kingdom is a signatory, states that the child, and I quote, needs special safeguards and care, including appropriate leading protection before as well as after birth. We need to ask ourselves, when we talk about conforming with what other jurisdictions do, how well we conform to those norms as well. My lords, things have changed as a result of the 2022 Health and Care Act. I took part in the proceedings of that legislation. On the fourth day, an amendment was brought forward to make permanent the COVID arrangements permitting at-home abortions. Let me remind the committee of the words of the then Health Minister, the noble Lord Camel, who told the House when announcing the end of the policy in February 2022, and I quote, that it was always intended to be a temporary measure. Too often, though, my lords, temporary measures become permanent and new arguments are brought forward to justify them. One of the key arguments which has been forward in support of Clause 191 today is the alleged rise in the prosecution of women in recent years. But that, if there has been a rise, is intrinsically linked to the abortion pills by post. I was particularly struck that for the 160 years prior to 2022, it was acknowledged by Jonathan Lord, now of the Royal College of Gynaecologists, but a former medical director of Mary Stopes, that, and I quote, only 3 women have ever been on trial. Between the 1st of January 2012 and the 31st of July 2022, data from the Metropolitan Police shows that of 42 arrests under sections 58 and 59 of the Offences Against the Persons Act and the Life Preservation Act, 34 of those arrested were men. And of the 7 who were ultimately charged, none of them, my lords, were women. Prosecutions of women, I'm glad to say, remain very rare indeed. And I know this, but there is agreement across the House, because we've all said it during the course of the debate today, that any investigation of a woman following a pregnancy loss is a matter that requires deep compassion and sensitivity. And like others who have spoken in the debate, those of us who are fathers have experienced the loss of a child as a result of miscarriage. We know what that means for men as well as for women, what it means to everyone. It's the loss of a new child. Either life begins at conception or it doesn't. If it does, then the sanctity of human life that the noble Viscount Hailsham described earlier on surely must be a consideration. I acknowledge that there may be circumstances where accessing care and support may be less straightforward, but that doesn't justify the removal of in-person clinical safeguards altogether, particularly where there are well-documented risks around gestational error, coercion, and missed complications. A compassionate and appropriate response is surely to address access problems through properly funded local in-person services, targeted support for vulnerable women who may be coerced or even trafficked, rather than relying on a remote model that prioritises speed and convenience over safety. There are, my lords, radical alternatives to the defeat which many have said in this debate, wherever we come from on the substantive issue. Many have said abortion itself isn't something that is good or desirable. We must do all we can to try and find alternatives to it. My lords, instead of asking a select committee to examine the sorts of arguments we've heard today, instead of having pre-legislative scrutiny, instead of examining those dangers to women, instead of examining the inevitable increase in the number of terminations, instead of looking for alternatives which promote the well-being of both a mother and child, instead of even having an impact assessment, as one noble lord rightly referred earlier on, proceeding without an impact assessment, proceeding without any of those normal requirements in promoting legislation, this new clause was added simply as a backbench amendment at a late stage of a bill which is not primarily about abortion, and it was given a cursory 46 minutes of backbench debate in the House of Commons. That would not have happened and did not happen in my day in the House of Commons, my lords. This is no way to make law, and the government would be well advised to withdraw this clause pending further consideration of the practical issues that it raises. The uncomfortable truth which all of us must wrestle with, irrespective of our in-principle views on abortion, is that with clause 191 on the statute book, if a woman intentionally induces an abortion at a very late stage and the baby dies in utero or during the process and is not born alive, there would be no criminal offence available in respect of her actions, regardless of gestation. My lords, abortion pills are powerful drugs. They can involve significant bleeding, pain and complications, and they can be tragically misused. The purpose of an in-person consultation is not delay or obstruction, but to provide a vital clinical and safeguarding checkpoint. And I would urge noble lords, even if they cannot support the substantive objections that I've made to clause 191 in supporting the noble Baroness Lady Monckton, to at least support Amendment 460, which was spoken to by the noble Baroness Lady Foster and is in the name of the noble Baroness Lady Stroud. And I hope that when we return to this question at report stage, there may have been some movement in that direction.